The next case is Cassedy v. Wood. That's Cassedy, C-A-S-S-E-D-Y, Cassedy v. Wood, W-O-O-D. The opinion may be found at 44 Florida Law Weekly, D4228. The opinion was issued by Florida's 1st District Court of Appeal on February 11, 2019. In this case, the landlord sued 3 joint tenants for breaching the lease. The lease allowed attorney's fees to the prevailing party. However, the landlord served each tenant with a proposal for settlement in the amount of $25,000 pursuant to Florida Statute Section 768.79. The proposals were rejected, but the tenants were found jointly and severally liable for $83,000. The first question on appeal was whether the trial court had erred in awarding the landlord attorney's fees under the lease, but denying attorney's fees under Section 768.79 on the grounds that the landlord was only entitled to one attorney's fees award. The 1st District Court of Appeal said yes. The court explained that contractual and statutory attorney's fees may be awarded simultaneously because they serve different purposes. Contractual attorney's fees are intended to make the prevailing party whole, while statutory attorney's fees are intended to punish the losing party. The second question on appeal was whether the trial court had erred in awarding the landlord attorney's fees under the lease, but denying attorney's fees under Section 768.79 on the grounds that the settlement proposal was unclear as to whether the amounts offered should be aggregated in determining whether the judgment is at least 25% greater than the amounts offered. The 1st District Court of Appeal again said yes. Under Section 768.79, separate settlement offers may not be aggregated when determining whether the judgment is at least 25% greater than the settlement offer.